SJC-11316, Commonwealth versus Casey Cole.
Okay, let's proceed. Good morning.
Good morning, Chief Justice Ireland and honorable justices, Beth Eisenberg and Laura Mannion-Banworth for defendant Casey Cole. There is no definition in our statutes for the sentence of lifetime parole, only its administration, as described at Chapter 127, Section 133D, is set out in the statutes. And if nothing else, we think that this case establishes that when judges and lawyers speak about lifetime parole and talk about lifetime parole to their clients, there's really no basis for the assumption that we all know what it means. In this case, the defendant's chief claim is that the statutory design of the lifetime parole statute violates Article 30 of our Constitution and violates the due process provisions of the state and federal constitutions because the lifetime parole statute defines parole revocations as graduated increases to the original term of imprisonment. And it provides that these increases are to be imposed by the parole board. And what we suggest in our brief and what we suggest in our reply brief is that what that means is that the revocations are not revocations, as that term is generally understood when we talk about parole revocations, but they're new and additional sentences to the original term of commitment as required by the legislature, and they're sentences that are unconstitutionally imposed by the executive branch and not the judicial branch. Now,
so would I was analogizing it to probation, so the difference, I take it, is you could have, violations of probation, which the probation department notices, but it's the judge who actually, has to find the violation. And if it's a suspended sentence, then that's automatic, but it's the court that finds the violation. So,
yes.
So is that one of the aspects, or is it, in other words, there seems to be two things here. One is there's an automatic penalty that
Yes.
comes in, but
Yes.
more to the point, it is that there's an adjudication of
Yes.
something happening.
Yes, and the adjudication is at the original event, so that there isn't this revisiting. I mean, if you look, for example, at the supervised release statute in the federal system, the defendant is going to know when he's given supervised release, which is probably the best analogy I think I can make to lifetime parole. It isn't lifetime, but when the offender is told by the court that the court is going to, in its discretion, impose supervised release, that individual is given a blueprint of what can happen to him on supervised release. And so it is a sentence that is imposed at that time, and future events are brought back to the court to either to put into place the possible sanctions that the court warned the defendant about or not. Now, the government here doesn't contest that the increases to this sentence, this original sentence, are penal in nature. They did not go on record as saying, well, no, these are really just revocations. They agree that they're penal, but what they argue is that these future increases are an inherent, embedded, contemporaneous series of untold number of suspended sentences that are incorporated into the conceit of lifetime parole, and that they're kind of gestating. There are these suspended sentences that are kind of gestating while the person remains on lifetime parole.
Let me ask you sort of like a variation of what you're talking about now. Could the legislature, I know they didn't, but could the legislature have said, look, for all sex offenses, the offense is a mandatory life sentence? and then structure the sentences in certain ways such that a violation, such that a conviction of indecent assault and battery will result in a direct sentence of, the judge can set it, of up to 2.5 years in the House of Correction or maybe 5 years in a prison, and the person will be placed on parole thereafter for the rest of his life. And then, the parole structure would operate as you've described the parole structure traditionally operates.
So when you say put them on a life sentence at the outset, are you talking
Yeah.
about a committed life sentence?
I'm talking about a life, the punishment for indecent exposure
Okay,
is life in prison.
all right.
It's mandatory. But it'll be structured in such a way that the first 6 months will be served in jail, and then you're on parole for the rest of your life. Could the legislature do something like that?
I think there'd be a really good argument that might violate Article 26.
Disproportionate.
Yeah,
Yeah.
but, I mean, in terms of structuring it that way, I don't see an immediate problem, other than it seems kind of irrational to me. I mean, I think there would be a good argument to be said that it's hard to see the legitimate governmental objective in penalizing someone that way. But I mean, in terms of how it's structured, I think so. I think, as I said in the brief, the main flaw here is this sanctioning provision at subsection C, which provides that these individuals never see the court again, ever.
Isn't there an Apprendi problem with
There
each
is
of
an
these?
Apprendi problem
I mean,
as well.
each time, each
Yes,
violation?
absolutely.
Because it is, by definition, increasing the sentence.
Exactly. Based on facts that were not before the judge, a jury, or admitted by the defendant. We identify it as a Booker problem in the brief, but it's really that those cases and their progeny that talk about. Because what does that mean? It means that an individual who's sentenced by the parole board for coming home 10 minutes late on curfew, that fact is the aggravating factor. And that fact has nothing to do with the law that permits aggravation under the original sentence. I mean, there is no such thing as lifetime parole because you're a level 2 and you came home 10 minutes late for curfew 6 months into the future. I mean, it's Alice in Wonderland.
But what
Well,
you're
if-
suggesting, go ahead, Chief.
If you prevail, let's say you persuade us to agree with you, are you saying that there would, going forward, be no lifetime parole?
There would be no lifetime parole under this particular construct. What the legislature would have to do, I mean, there are a lot of different ways that this can be done. People can be put on longer periods of probation, and in fact, longer periods of probation for certain individuals where it's warranted seems sensical because the courts know those people.
Well,
And,
then would that just be changing the terminology from lifetime to parole to, say, you're going to be on 50 years probation?
Lifetime probation.
Right, or
Community
supervised
probation.
release.
Yeah.
Yeah, I
Community
mean, that's
probation.
essentially what they have in the federal system, although it's not for life. Life is unique to Massachusetts.
But that would involve the court every time there's a problem.
Yes, every time there's a problem. And in the federal system, just as with probation surrenders, individuals get counsel.
But it would also set an outer limit as the total amount of time somebody could spend in jail. It would be the original sentence, wouldn't it?
It could be, yeah. I mean, you're right, because alternatives create this problem of life on the installment plan, and that is what people are doing.
Well, let's assume exactly the same statute, the same construct, except it's, I mean, in terms of, 30 days for the first violation of conditions, 6 months for the second, 1 year thereafter. But it's community probation supervision for life, and the court will essentially decide whether you violated the terms. But the same construct, not parole board, but court.
But, and with mandatory sentences,
Yes.
I mean,
The Apprendi problem go away? Is there an Apprendi?
Yes.
Is there really an Apprendi problem here?
I don't think so, if that's the construct, because all of those sentences are based on, they're really based on the facts that were presented originally to the court. It's the facts that prompt the revocation may be facts that prompt the revocation, but the revocation itself relates back to the original offense. If it doesn't, that is a real
Wait, I
double
don't
jeopardy
understand that.
problem.
Let's assume these same plethora of conditions that the parole board imposes on sex offenders become conditions of probation.
Okay.
In the construct that Justice Cordes just said.
Yes,
And so somebody uses the computer without permission.
Yes.
And that's the second time that he's done that.
Right.
So he comes into court, the court finds that indeed he has used the computer without permission.
Right.
And automatically then sentences him to 180 days, right?
I see. You're right.
I mean, isn't that
is
still?
that's the same problem. That is the same problem.
Why?
That's not relating back to the offense.
That's right. It's right, because it's based on facts that were not part of the original. There may still be an Apprendi problem. There would not be an Article 30 problem.
Right.
But there may still be an Apprendi problem depending on what factors it is that prompts the court to impose a mandatory sentence
Right.
on the individual.
But why isn't the probation and the penalties for its violation part of the original sentence? It's imposed at the time. I'm sentencing you to 2.5 years in prison and community probation supervision for life thereafter. Why isn't,
Because if the original sentence is a period of imprisonment and then lifetime.
part of the sentence? This is your
Lifetime.
two-part sentence.
Well-
It's like 50 years from and after probation. I mean, it's
Yes,
part
but
of the sentence.
it's a mandatory, incarceration as a result of a violation that hasn't happened yet.
Right, exactly, and that is the problem, because you can't, nobody can tell the defendant what the maximum penalty is going to be. He doesn't know what the maximum.
But he does. At least I think the construct that Justice Cordy is suggesting, let's say the person gets a 3 to 5 year sentence, okay? And you are on lifetime probation or 50 years probation. And if you violate the terms of your probation, a judge has the option of either continuing the probation or sentencing you to imposing the original sentence of 3 to 5 years. Now, that's a different problem if you get if we're talking about.
These intermittent punctuated sentences.
Yeah.
Right, and that's what I was
But
talking about.
But if you had a sentence, just any sentence that was suspended, so you have, you serve 6 months and the balance is suspended, and you violate your probation for absolutely nothing to do with the original crime, but just because you don't do drug and alcohol counseling, something like that. So you violated your probation, judge finds that, there's a suspended sentence, has to impose it, right?
Exactly, under
So
Holmgren.
that's not an Apprendi problem,
That
right?
is not an apprentice.
And you're done. You're done with your sentence.
Correct, yeah.
Yeah.
Yeah. I want to talk a little bit about the language. What we think is that it really would be utterly superfluous to say the original terms of imprisonment, that these sentences are in addition to the original terms of imprisonment, if the government is right, and in the original terms of imprisonment are embedded these untold number of suspended sentences. We also think that there's a problem in terms of 133DC's talking about an increase to the original term of imprisonment with respect to people like Mr. Cole, because Mr. Cole only got 6 months probation. So do the sanctions of lifetime parole revocation apply to him at all? I mean, he didn't get an original term of imprisonment. He got a 6 month straight sentence of probation. He finished it successfully. He was, he was discharged from probation, and at that point, he's on lifetime parole. What happens when he's revoked? He's certainly in jeopardy, I think, of being revoked at any time, every single day. I think he certainly has standing with respect to these issues, because if he doesn't write down in his notebook the starting odometer of the bus he takes and the ending odometer of the bus he takes, he's going to jail. Or if his GPS monitor does not function properly, he is going to jail, mandatorily. So what happens to people like that? What did the legislature mean? Because we know in the failure to register statute, they are supposed to be on lifetime parole after probation, probation is finished. I see that my time is up. I just, in summary, what we ask the court to do is to find the lifetime parole statute facially unconstitutional under Article 30, and we ask the court to say just that. Thank you.
Good morning. May it please the court, Mary Lee, Assistant District Attorney from the Plymouth District for the Commonwealth. The defendant's first claim in this issue is whether the statute violates separation of powers. And the defendant's claim is based on the language in Chapter 127, Section 133D-C, where it talks about the entire period of confinement and then increased punishment to the original term. And I would point this court to the Sheen case, which is cited in the Commonwealth's brief. In that case, it was a juvenile who was sentenced to serve his time at a particular facility, which was for juvenile rehabilitation. After his behavior at that facility made him a person who was not manageable, the executive branch, which is the juvenile department that housed him, moved him to the stricter facility, as was permitted by a different statute in Chapter 120, I believe. And so what this court said in Sheehan is that that provision for the movement of him to a stricter statute, stricter rehabilitation facility or detention facility, caused by his conduct between the sentence and the time of the move, was as much a part of the sentence as if it had been extended at length on the record in court. And this court went on to say whether the defendant's conduct requires that stricter implicit condition is not necessarily a judicial function in nature.
Well,
isn't it-
so a person commits the crime of indecent exposure. I don't know what the sentence is, fairly small, goes on lifetime community parole, and for the rest of his life, keeps on screwing up and ends up spending 50 years total time in prison for indecent exposure.
And has never been back to court because the
Yeah.
parole board is doing it.
Yeah.
As
What's wrong with that picture?
As to the first part of that question,
Yeah.
the harshness of the sentence doesn't make the determination whether there's a separation of powers violation.
But this,
That's
that
cruel and
person's
unusual.
never going back to court.
And that gets us to the separation of powers argument. So that's actually two-prong. And the Commonwealth concedes this is a harsh penalty. And that's why I went into in my brief, the reasons why the legislature imposes this. It's a harsh penalty. And the question before this court is not whether it's cruel and unusual. The defendant has not, they started with that in their motion, but they have not pushed that on appeal. So that is not before the court. So the harshness of the sentence is really irrelevant to whether this violates separation of powers. But the
Let me ask you,
secondary,
let me ask you this, though. All right, who sets the conditions?
the conditions of parole are set by the parole board.
Not by the court. Set by
According
the-
to the defendant's record appendix sets those, includes
they're-
what those provisions are, yes.
They're set by the parole board.
I believe that's under the authority of the statute.
Right. Now, I take it the penalties here are 30 days, 180, and then 1 year for violations thereafter.
Those are mandatory terms, no discretion on what the terms are.
So would you say the legislature could have set them at 1 year, 3 years, and 5 years?
The legislature has the authority to set the sentence within the confines of cruel and
Conditions are going to be
unusual.
set by parole. These aren't conditions of release. These are conditions going forward, having nothing.
Yes.
Okay. And then if there are violations, the parole board could sentence whatever the legislature says. And is there an appeal from that?
Under Stefanik, when there are parole violations, someone can contest their ability, and it's usually done through a lawsuit against the parole board.
test their
Civil suit?
ability to
Civil
what?
suit?
A civil
Yes.
suit? So there's no appeal from the imposition of whatever the legislature says the parole board can do as a sort of a adjudicatory body.
Well, under Stefanik, this court has ruled that parole violation proceedings and that the appeals that draw from that through usually a civil suit are compliant with due process.
But these are not really parole violation proceedings. This is something very different.
Well, that's the question before the court.
Well, isn't it something different?
Is that different? And I note in my brief, this is not traditional parole where
Not at all.
someone, the parole board releases them.
This is someone.
This is a parole that is set from the sentence. And so just the use of the term parole needs to be looked at in terms of that this is lifetime community parole and not traditional parole. But I would
Sounds
suggest—
a lot more like
More than
probation.
that, that's different.
Lifetime probation.
I understand what you're saying, yes, and they are comparable, but in this case, I would point to, again, to Sheehan, because what the court said in Sheehan, even though it was a stricter sentence, it was a harsher penalty.
Yes, but it did not increase the time of the sentence, did it?
That's true, but it was a harsher penalty. And so I would point to Sheehan and say that that did not constitute an added or greater sentence, even though it was done by the executive. And I would also point to this court's decision in Corey, which was a probation case in an ex post facto analysis. But in that, Corey said the penalty of additional supervised release are attributable to the original conviction. And that's the Commonwealth's position in this case, that within—
Again, it's not, there's nothing about Corey that increases the sentence or imposes a new sentence, is there?
I believe in Corey that was that was the GPS monitoring
Right,
requirement.
that's
So it was
right.
an additional condition. So the Commonwealth's position on this case is that when the court imposed lifetime parole, what came with it, just as in Sheehan, was all the requirements of lifetime parole. And therefore, it is the court that is imposing this sentence that has the graduated sentences described in the statute as increased
But the
penalties.
court isn't the one who's adjudicating whether the graduated sentence comes into play or not.
Right, and I would suggest in this case, as I noted in my brief, the defendant has not yet had a violation proceeding, and so it is not, in this case, I don't know, I know the other cases today involve lifetime parole as well, so I don't know if the other cases have a record that support what the parole process is and whether that complies with due process. But I would suggest that it does comply with due process because this court has mandated in Stefanik that the parole violation proceedings comply with due process, and that the conditions that are set forth that are in Morrissey versus Brewer, the probationary context, that say that's constitutional to have those conditions that are set forth by the parole board here are indeed consistent with what is set forth in Morrissey versus Brewer.
But Morrissey versus Brewer was based on a parole which was the traditional parole,
Yes.
where there's a sentence set by the judge, and the parole board can only reduce or can only allow part of that time to be spent at one's home or on the street. Here we have a situation where it's essentially more analogous to what you say is a series of suspended sentences, which would come to the court for probation in a more traditional setting, but the defendant would get an attorney. He gets no attorney in a parole board. Isn't there something elemental about the fact that what makes this different is that we're not merely saying parole can cut you a break from the sentence the judge imposes, but here you're getting additional time above and beyond what the judge imposed, and even under your analogy, you're causing a suspended sentence to be an executed sentence.
Exactly. That is why this type of parole is different from traditional parole, and it wasn't intended by the legislature to be the traditional parole. That's why they went to great lengths to define it. But I would suggest that if the parole violation process meets due process under the traditional realm, then the parole violation process would be the same in this case, meeting due process.
But if that's the case, if that's the case, then it would satisfy due process to have no counsel at a probation violation hearing.
Right.
But I don't think we'd go there. I assume we've already said you do have right to counsel when you're facing 1 year in jail as a result of a probation violation hearing.
And I think that's because of the automatic penalties. This isn't a judge fashioning a sentence after a probation revocation, decide whether to impose, first whether to find as a violation, and then
Yes, but
impose the-
you're forgetting that somebody's got to adjudicate whether there was a violation.
Well, I would suggest that's where Sheehan comes in. Sheehan would state that it's proper for the executive branch to make that determination in those circumstances when that statute is subsumed within the original sentencing statute.
Of course, it seems to me that part of the problem that you're facing is under traditional parole, and I think it takes it from the word parole, the defendant has to, first of all, he has to apply for parole. If he doesn't apply for parole, he can serve his sentence and walk out the door and say sayonara, and lead his life so long as he doesn't, commit another crime. He's free to do whatever he wants. He makes a deal with the state. He says, if you let me go, I promise I will not do anything wrong. And if he violates his parole, his contract, he goes back to jail for the rest of his original sentence, and then he's free.
Right.
But here,
here
he
it's
finishes
graduated.
the original sentence that the court imposed, and then it's the parole board that then embarks on a journey of punishing him for various misdeeds that aren't necessarily even crimes.
So I would suggest that sort of gets us to the Apprende issue that Justice Botsford was asking earlier. And I would suggest that this isn't an Apprende issue at all. And I would point to Sheehan as resolving that. And the reason why is that when you have, for example, a probation revocation, as was noted earlier, that you wouldn't have those original violations of probation, that can't be charged and proved at trial. And so with those things, that doesn't violate Apprende. And Apprende doesn't have any prohibition on enhanced penalties in it at all. It doesn't say that you can't have probationary periods or parole periods with these new conditions put on them. That's not what Apprende says. Apprende says you need to allege the aggravating factor, which was done here, unlike the Kately case, and that you need to prove it, which was done here at the guilty plea, and then you get the sentence, and the sentence was announced to him. That's the sentence. That sentence appears in the complaint. That sentence was talked about prior to the plea. The defendant was given an opportunity through his attorney to make a statement on it. He did not. And in the reply brief, the defendant pointed to Rule 12.3b, and I would ask you to look at the language of 12.3b. It's talking about the maximum sentence. That's what the defendant's concerned about, that no maximum sentence is given to the defendant during the plea. But 12.3b says, where appropriate, he has to be notified of the maximum possible sentence on the charge, and where appropriate, the possibility of community parole supervision for life. Well, this was discussed. You'll see it at DR 37. I realize this isn't inaudible.
Make it okay.
I'm sorry?
The fact that it's listed there doesn't make it okay.
No, I understand. This goes more to the notice issue, and I wanted to address that. The defendant had the notice, and he agreed to this as found by the judge. He didn't make a comment on it. Then he's given an opportunity after the colloquy himself to make a statement. He's got no comment. It's imposed on the record, unlike Williamson, no objection. It's not until the lifetime parole starts to take effect that the defendant then brings his claim against this. So this idea of, did he agree to it or not? Well, he did agree to it here.
Well, I mean, this is a plea situation, but there are cases where there is not a plea situation, and, and it's imposed after a jury verdict. And he's serving a sentence for conduct is yet to occur.
Yes.
He's serving multiple sentences in the future that have never been adjudicated by a court or a jury or with the right to counsel.
When I just said yes, I mean, I understand your comment, but I would suggest that that's contrary to the statement of the law in Sheehan, that this goes back to the original sentence imposed by the judge. So that's the Commonwealth's position, that this is the original sentence imposed by the judge with notice, with an allegation in the complaint as Apprendi requires. The defendant admits to the level 2, which is the aggravating factor. And I didn't make a comment that this was a remedial statute because Pagan says this is an enhanced penalty. So I didn't feel like
Clearly
that
is.
was a legally colorable argument. So that my sister raised that, and I just wanted to point that out. I didn't not think about it. It says it in
guess,
Pagan, it's an enhanced penalty.
Even if it is a suspended sentence, as you say, it should be characterized, and even if that survives Apprendi, is it not a judicial role to decide that a suspended sentence should be executed? Which is a little bit different from what parole traditionally does. Parole board is using an executed sentence, it's being served, and says, we will cut you a break.
Well, you would, at first blush, you might think that way, but I would suggest you should look at it this way, that the parole board's traditional role is to determine whether there's a parole violation. And if not, then to reimpose the mandatory sentence. And it's not, the judicial issue there is what sentence should we apply? And in this case, that has been taken away and given by the legislature. It is mandatory. There is nothing else to be done. If there's a violation, these are the sentences to put in. And so that's why it's not a judicial role. They have no discretion on what sentence to apply.
Well, it's just, the difference between traditional parole, where you're cutting somebody a break from a sentence, and where you are imposing new, as you would put it, suspended sentences every time, is fairly fundamental.
I understand, but the legislature's choice of naming this parole is not the deciding factor. And if there's a reasonable way to interpret this statute as constitutional within the separation of powers, this court should do so.
That's not the problem. The problem is it shifts all of this to an executive agency to adjudicate things in the future, to adjudicate and punish things in the future. It just shifts all of that
is
to
what
an
the-
executive agency.
That is what the parole board does as the executive
doesn't.
agency. They determine whether there are parole violations.
Yeah, but, oh, well, never mind.
And your point is that Sheehan says what Sheehan says, and we may just have to take another look at Sheehan.
That may be the case. I would ask you, if there are any further questions, I'm happy to answer them. I apologize for going over
Oh,
time.
it's not we did it